Dylan Brooks versus Heathery Avery Andrews.
Okay, we will now hear from the appellant.
May it please the court. I am Joseph Smith, along with my co-counsel Gil Bowie. We represent the appellant, Heather Avery Andrews. For purposes of today's argument, I will refer to the appellant as mother and the appellee as father. At issue before the court is whether father had standing to file his December 2020 complaint in Shelby County Chancery Court. It's our position that father did not have standing to do so for these two reasons. One, father did not have a right to sue for parentage of a child born out of wedlock in Chancery Court because venue for such actions is in Shelby County Juvenile Court pursuant to statute. Secondly, father did not have the right to sue for immediate emergency custody of a minor child born out of wedlock because parentage had not been established. The following are critical.
Let me ask you a question, Mr. Smith. Is parentage an issue here?
Parentage? No, parentage is not an issue. We have a pending parentage action in California. What is at issue is custody and visitation, which is required for an agreement for parentage to be established.
So everybody agrees that the father, the purported father here, is the father?
Yes, Your Honor.
Okay. All right, sir. Go right ahead.
Okay. The following are the critical facts for this court to consider and determine whether father had standing. Prior to the filing of the December 2020 complaint, the parties had dismissed their respective parentage actions in October 2020. Father dismissed his Nevada action and mother dismissed her California action. Since then, no order has been entered that established parentage. No VAP had been executed, VAP standing for Voluntary Acknowledgement of Paternity. And no agreement consistent with Tennessee Code as to parentage has been made. And with the complaint that was filed in December by father, what was sought was essentially three things: to establish custody, temporary emergency custody pursuant to UCCJEA. Secondly, to establish child support pursuant to USA. And thirdly, a restraining order be issued against the mother. With respect to our first argument, the complaint that was filed by the father in December 2020 is one for parentage. That is addressed pursuant to TCA 362311. That statute controls with respect to an order for parentage. Now, venue for parentage actions is localized by statute. That is TCA 362307A. So based on our interpretation of the statute, parentage actions involving a child born out of wedlock has to be filed in Shelby County Juvenile Court, not Chancery Court. This interpretation is consistent with the Attorney General's opinion, 10-91, and is not being challenged by the father. Now, father is now asking that this case be transferred to juvenile court if the court finds that Chancery Court did not have subject matter jurisdiction. And it's clear with case law that once this court finds that a court doesn't have jurisdiction, subject matter jurisdiction, dismissal is required. Now, interestingly, the father says on page 36 of his response that he did not have the option to file his complaint in juvenile court in December 2020. We take issue with that. For one, the Supreme Court had issued an order that provided exceptions to the prohibition with in-person hearings. And father's complaint falls exactly within that exception. So as long as the juvenile court Shelby County was following the order issued by the Tennessee Supreme Court, it's just not true that father did not have the option to file in juvenile court. With respect to our second argument, we rely on the analysis that this court had provided in Baxter v. Rowan. Here are the following takeaways. The code provides multiple ways for a unwed father to establish parentage besides 36-311. And an execution of a VAP is one way, among others, to establish parentage. Here, the only route for the father in this matter to establish parentage is through 36-311. So it follows that father lacks standing to seek immediate temporary custody of the minor child. And just to be clear, 36-311 requires that a paternity test be done, and that did not occur. We're not saying that father didn't have standing to sue at all for custody. He did. But mind you, what was requested at the time he filed his complaint was only for temporary emergency custody. At that time, unless father could show that he had a legal right to custody, which he did not, the court had to order paternity testing, and that did not occur. Now, father argues that
how would he have the right to sue for custody if parentage hadn't been determined and he hadn't signed a VAP? On what basis would he be entitled to sue for custody?
He wouldn't have a basis to sue for immediate custody, but he would have basis to sue for custody, because at that time, the court can say, well, let's issue an order for him to undergo testing. Once the results come back that he is the father, then we can establish custody and visitation.
So in other words, prior to that, the court would have to determine parentage.
Correct.
Okay, all right, go ahead.
Correct. In this case, that did not occur. Now, father argues that he has standing due to a DNA test and the fact that mother is asserting that father is the father of the child in California, a pending jurisdiction. Well, here's the problem with that. DNA admissibility is contingent upon complying with testing requirements pursuant to TCA 24-7-112. And there's no legal authority presented by father to support that a DNA test is equivalent to granting one custody, paternity or parentage. Same with the pending action. Although mother is not disputing parentage, there is a mechanism for the parties to agree to parentage. And one of those requirements is that the parties have to agree to custody and they agree to visitation. That's not this case, not to mention that we are currently challenging Tennessee's jurisdiction over this matter. So in conclusion, Your Honor, it's our position that father did not have standing to file his complaint in December 2020. Not only did not have standing to file in Shelby County Chancery Court, but based on what was requested in his December 2020 complaint, he does not have standing to sue in a juvenile court based on what he was requesting. Now, there is a remedy for the father. His complaint alleges emergency allegations. And one route for him to go would be to file in juvenile court an action for dependency and neglect. And he will have standing under the statute. Also, he would be able to obtain an order for emergency custody based on probable cause that the child is dependent and neglected.
In this case, was an evidentiary hearing ever held?
The hearing was ex parte. So I believe evidence was taken, but there was no notice to the mother and no opportunity for cross-examination.
Well, I mean, have you seen a transcript or was evidence presented other than?
Yes, I believe the record includes a transcript from those proceedings.
Okay.
Mr. Smith?
Yes, Your
I
Honor.
believe you stated that your client has a case pending in California. Is that correct?
Yes, Your Honor. Yes.
When was that filed?
That was filed in January 2021, January 20th, I believe.
Right. And that is an action to establish parentage. Is that correct?
Yes. Currently, they are having a hearing that's set. They had multiple hearings. Ruling has not been made, but I believe they resume in January this upcoming year.
All right. Thank you.
All right. No other questions. We will hear from the appellee.
And I'm out of time.
Okay. Thank you. We will hear from the appellant in rebuttal.
Thank you, Your Honor. To answer your question, there is no legal significance. Going back to the analysis of Baxter v. Rowan, the court acknowledged that the execution of the VAP was of legal significance because per statute, it gave the father legal rights. Here, we don't have that. Now, like I stated earlier, there is a way for the parties to have that legal determination made by agreement. That is pursuant to 36-2-305, agreement to establish parentage. And it says the court may enter an order of parentage upon the agreement of the mother and father, unless the court on its own motion orders genetic testing. So there is a way. However, it goes on to say that any agreement under this part shall comply with the requirements of 36-2-311. Now, 36-2-311 requires a paternity test to be done, and also that a determination of custody, visitation, and parental access. We don't have that. So again, to the fact that the parties agree that Mr. Brooks is the child's father, that is of no legal significance. And opposing counsel has failed to provide any authority to support that a DNA test, despite its authenticity issues and it being just black letter law hearsay, does not give one, a father, legal rights. It doesn't establish, there's no authority for that, at least that I've been made aware of. Now, going to the UCCJEA, the UCCJEA in of itself is not some vehicle to establish parentage. The UCCJEA is merely a procedural means to determine whether which court should have jurisdiction over a particular matter. It doesn't address venue, which is specifically addressed by the Parentage Statute 36-2-307A, and doesn't address standing to suit for visitation and custody rights. But lastly, Your Honor, it was very troubling for me to listen to the explanation of why counsel decided not to file the action in juvenile court. This is news to me. This is news to the court. As you know, that courts speak through their orders. And the Chancellor Jenkins' order does not mention that there's no other court of resort for Mr. Brooks to file. I don't remember seeing that in the record, Your Honor. What was clear is that Chancellor Jenkins assumed jurisdiction based on the reliance that the UCCJEA 36-6-219, I believe, I might be mistaken by the numbers, but the temporary emergency authority. Now, again, there has to be some type of vehicle for the court to assert that authority. The court could have asserted that authority under dependent and neglect action, because dependent and neglect actions might rely on the UCJEA, as well as a parentage action. It was clear that the court just did not have authority in this matter, and we asked that this matter be dismissed and remanded to determine fees.
Let me ask you a question. Is there any portion of the UCCJEA that deals with standing that you're aware of in these type situations? Or is standing a state by state determinative question?
It is a state by state determinative question. If one would just do like a copy and paste of the UCJEA and do Control F standing, you'll find it in one section, that is in the comment section. And our reply brief addresses this issue. And essentially, the UCJEA is a mechanism for states to determine who has a person jurisdiction over custody, and then leave that issue of standing up to the states to decide. Now here, parentage actions, the Parentage Statute addresses standing. It's just standing in the context of venue, because here we have a venue is localized by statute, as well as what is required to obtain parentage pursuant to 36-2-311.
Okay.
How long has this child resided in California?
It's our position that she resided in California majority of her life. The child was born in Nevada. And I know this is not in the record, but the purposes of Nevada was to be closer to the mother's family to birth the child. But she resides currently right now and at all times in California.